Welcome to Canadian Justice. I'm Christine Van Gyn. Today we're talking about the federal government's recent announcement that they're going to be eliminating mandatory minimum sentences for several drug and gun-related offenses. Mandatory minimums mean that everyone who is convicted of the same crime will automatically receive the same minimum term of imprisonment. Parole eligibility is limited and flexibility is taken away from judges. But the effectiveness of mandatory minimums as a sentencing tool has been questioned, and some of them have been challenged in the courts, and a number of them have been struck down as unconstitutional. Some politicians have now changed their views on mandatory minimums, arguing that it leads to over-incarceration of non-violent offenders, and that it leads in particular to the over-incarceration of Black, Indigenous, and marginalized people. In February, the federal government announced a new bill that would repeal 20 mandatory minimum sentences, including 6 mandatory minimums for drugs and 14 mandatory minimums, including minimums for possession of firearms. But other mandatory minimums remain in place for murder, sexual assault, and for impaired driving. Some experts believe that the government rollback has not gone far enough, but others see the value in mandatory minimums in the right context. Today, we'll be looking into this debate. We're going to be first joined by Andrew Murray from Mothers Against Drunk Driving to look at some of the mandatory minimums that will be staying in place. Mr. Murray, thank you so much for joining us today. Could you explain to me MAD's position on the mandatory minimums that exist for second and third offenses of impaired driving?
Yeah, so those, to get a mandatory minimum, so a second offense that happens within a 10-year window, you would get a 30-day sentence. And as you know, most people would serve that sentence on a weekend, might serve 2 or 3, come in Friday, go out Sunday. The third offense, again, within 10 years, is a little more onerous. It's 120 days. You actually have to be incarcerated in a provincial institution for that. And I think society says, if you're caught and convicted 3 times of driving impaired and putting the public at risk, that's a reasonable sentence. So I don't think any of those 2 mandatory minimums will be challenged under the charter as unreasonable considering the period of time. I can tell you most victims of impaired driving would say it's not enough, but you've always got to balance, the charter and what can be struck down. And so it becomes much more of an issue when you look at issues like impaired driving causing bodily harm or causing death, which don't have minimums. And that's really more the bone of contention with victims of impaired driving.
And what's MAD's position on that? Do you think there should be mandatory minimums for those offenses?
We don't, because to meet the charter, oversight that would go, that minimum penalty would have to be about 18 months to 2 years, because there's all kinds of different circumstances where judges want to be. It could be somebody that is totally disabled, after, even though driving drunk, that they've caused, great damage to themselves. They're not about to incarcerate a person. And people that are asking for this, and it does not include MAD, are asking anywhere from 5 to 7 years on a minimum penalty, which is quite a bit.
And you think that would be struck down if such a...
Absolutely. Absolutely. So yeah, we've done that legal analysis. So, but I mean, over the last 20 years, the courts and the judges have taken impaired driving causing death fairly serious. Something that, in 2000 might have been a 2-year sentence is somewhere in the range of 8 to 10 years. So the sentences have been rising. They're more in line with what is a fair penalty for crime committed. I mean, again, the families that are impacted get a life sentence. So they're, they don't understand when there's a maximum penalty of life and somebody who kills 4 of their loved ones gets 10 years and is out on parole in 5. It's a really challenging piece to explain, but mandatory minimums are not going to improve that situation.
It's certainly not what a lot of people think of, and I think that that's part of the problem is taking the flexibility away from judges means that they can't impose these sentences that the public wants. So thank you very much for joining us today and for the work that you do at MAD.
Oh, I appreciate it. Thanks for the opportunity.
Welcome back to Canadian Justice. We're talking about the federal government's plan to roll back mandatory minimums for certain drug and weapons offenses. Joined by me now are two criminal lawyers, Karima Saad and Ari Goldkind. Ari, I'd like to start with you. Some of these offenses where mandatory minimums are being repealed are, in fact, violent offenses. For example, using a firearm in the commission of an offense, discharging a firearm with intent, discharging a firearm during a robbery. Shouldn't mandatory minimums stay in place when the offenses are violent?
Well, that raises a great question, Christine, about the nuance in this debate. And there is very little nuance. People are either for it or against it rather than looking for a middle ground. One of the big questions here is, do we trust judges or do we not trust judges? And given some of the body politic today, the way people want the criminal justice system to move, people want incarceration to happen less. The question is, which people are those? Are they the people most vocal on Twitter and social media, or is it the ordinary average Canadian? But if somebody were to say to me, am I in favor of mandatory minimums? Mostly no, because it sort of handcuffs, pun intended, judges from doing what they feel they should. But at the same time, particularly for violent offenses, not necessarily drug-related offenses, getting into issues of addiction and other sorts of things, some would say, well, shouldn't Parliament have a say in setting a minimum floor for somebody who commits an act of violence? The end of the story, though, is judges still should maintain some discretion to sentence the human being that's in front of them.
Karima, what's your view on mandatory minimums? Is the government decision to repeal these particular ones a good thing, including those violent offenses?
I think it's a good start. It's important for people to understand that as it currently stands, there are many appeals and many mandatory minimums have already been found to be unconstitutional. So this is the government addressing some of that. And as far as a mandatory minimum goes, I think the question to ask is it serving a productive purpose, or is it a form of bloodlust because someone has committed an offense that is problematic? And that's not to undermine the seriousness of some of these offenses, but the research indicates that mandatory minimums don't actually serve a purpose in terms of deterrence. They can be counterproductive. And in fact, the data reveals that those who are most affected by these mandatory minimums and end up overrepresented in prisons tend to be Black and Indigenous Canadians. And so that is an issue that repealing mandatory minimums is a start.
Could either of you tell me an example of a case where mandatory minimums have been imposed in an unjust way? I know there must be a number of examples, but just to give our viewers a sense of the flavor of when this is unfair.
Who would you like to go first?
Ari, let's start with you.
So for me, I can come up with a number of examples, and I want to go back to your first guest for a moment about impaired driving. I think that's an important point to touch on when it comes to mandatory minimums, because remember, many people don't want mandatory minimums when it touches them in a certain way, but most people support mandatory minimums for murder or certain kinds of sexual assault or sexual abuse. Or, for example, if you've gone out and been drinking and driving for the third time, there's not a massive outcry for that. So there's a lot of politics involved in this. But the short answer for me is it's different when there's a person who's very morally blameworthy. For example, let's use the bank robbery example, robbery with a firearm. There might be a shooter, and that shooter or that person who puts the gun to the bank teller's head, there may be a much stronger argument for a mandatory minimum there. Where I see the injustice is, and this is called party liability. You don't have to be the central person, but perhaps the getaway driver. Perhaps it's somebody who's been pressured or is under the influence. They would be exposed to the same mandatory minimum as the actual designer of the bank robbery carrying the gun. So when it comes to party liability or people caught up in something that don't have the same level of moral blameworthiness, that's where I see more kinds of injustice happening.
Absolutely. And Karima, I'd love an example from you as well, but we're going to take that example right when we're back from this commercial break. Welcome back to Canadian Justice. And I want to follow up where we left off. Karima, I'd asked if you have an example of when mandatory minimums have been applied unjustly.
I think that in the context of drug offenses, and the Bill C-22 does address the mandatory minimums under the Controlled Drugs and Substances Act, that's where I have a lot of issues, and there are fairness questions, because where drugs are involved and there are underlying addiction issues, that's a public health issue, not necessarily one that's dealt with appropriately through criminal law. So I think that is a clear example, and given the context of the opioid crisis that we find ourselves in, it's an important stride towards better public policy.
Karima, I want to follow up on something that Ari had said in the last segment about the role that mandatory minimums could play. Do you think there's a role for them for certain types of offenses? I mean, they're not being repealed for those impaired driving offenses, for murder, for sexual offenses. Do you think that those mandatory minimums should stay in place?
They're probably, in the way that our current system is set up, I think that's been a feature, and that's not likely to change anytime soon. But back to the point about judges and discretion, and allowing a judge to, with the information before them, make a decision that is fair and reasonable and just in the circumstances. A mandatory minimum really it creates a floor, and the judge can go from there, and it ties their hands.
Now, Ari, there's an argument that mandatory minimums give the public a sense of confidence in the justice system. You read stories in the newspaper about someone committing a terrible offense, and then they're sort of sent away with a very small sentence. Do you think that they have a role to play in creating that public confidence?
Well, I think the term public today means two different things. Is the public that we're talking about and changing legislation about the public that's active on Twitter, that's active on social media, that has the loudest megaphone and bullhorn? Or are we talking about the ordinary average Canadian living at home quietly, a law-abiding life that says, look, once somebody is convicted, if Parliament says that discharging a firearm is something that there should be a floor for, that public may have a very different voice. So as somebody who's very interested in nuance, I approach it twofold. From a criminal defense point of view, I think to myself, why are we paying judges all of this money if they can't do the job that they're sworn to do because they're handcuffed? And remember, as Karima said, it's a floor. Somebody who does something vicious may get much, much higher than the floor is. But when we talk about the public, I am very reticent to generalize that the loudest voices in the room represent the majority of the people who often don't participate in the room.
Karima, I want to follow up with you on that. Do you think that there's an argument that these mandatory minimums are sort of politicians usurping the authority of judges?
Legislature has a role in deciding how laws apply. And then the judiciary interprets that in light of the Constitution. So I don't know that it's necessarily an overstep, but the practical effect is that it does curtail a judge's discretion. I'm not too sure about the dichotomy between Twitter public and average Joe public, because I think that there are some average Joes on Twitter. And I don't know that Twitter is representative of, I just don't understand that dichotomy. So, I mean, as far as how people view this, I think that the legislature has a role to make evidence-based decisions and not to appease a cry for more punishment, especially if that punishment, again, is counterproductive. And if we can be diverting resources to rehabilitation and to avoiding these social determinants of crime in the first place, I think that's a better role for the legislature to play.
And certainly the bill does propose that. It proposes diverting addicts in particular out of the criminal system and into a more medicalized system. I just hope that the resources are there to deal with that diversion. We're going to get back into this more after the commercial break. Welcome to Canadian Justice. I'm Christine Van Gyn, and we're talking about the federal government's plan to repeal mandatory minimums for certain offenses. Now, Karima, the federal government has said repealing these mandatory minimums is necessary to fight systemic racism. But if mandatory minimums unjustly incarcerate first-time nonviolent offenders, isn't that in itself just the problem? Why do we need to talk about race in this situation?
I think race is relevant to this situation if you look at the numbers. So just by way of one statistic, the number of Indigenous offenders in prison who were serving sentences that were mandatory minimums nearly doubled since 2007. So we went from 14% to 26% of Indigenous offenders. And when we think about the fact that Indigenous people represent about 5% of the population and 30% of the prison population, the increase in that prison subset of people who are there for a minimum amount of time is very troubling. And we take that into account alongside Canada's history and legacy of colonialism, of its relationship with Indigenous peoples that's been, by and large, abusive. And I do think that there's a moral imperative to address that kind of systemic discrimination.
Ari, I want to put to you some of the criticism that some politicians have made of justifying this based on systemic racism. So, for example, Alberta's Justice Minister has criticized ending mandatory minimums for gun crimes because he says it's actually often the minority communities who are being victimized by gun violence. So do you have a view on that perspective from some critics of this change?
Well, first of all, that's factually true. And anybody who's interested in being honest would say that that is factually true, whether it's in Alberta or whether it's in Toronto. It is also factually true that if you go into many of these kinds of communities that bear the brunt of this kind of violence, they don't share the same views of these issues as many of the loudest voices who carry the day. Many of these communities actually want more policing because they should be able to go for the same walk in a nice neighborhood that I or perhaps you could go in. So that's a very important point. Again, remember the issue of nuance. And there is a very significant difference between the root causes of certain things and things we can do to make the world better versus the idea that Crown attorneys, judges, police, people who call 911 are all acting with some unconscious bias. I'm not tempted by that argument the way some are. To me, at the end of the day, if we're talking about sentencing, mandatory minimums, or crime, you cannot have a discussion of these issues without being focused on truth, nuance, and understanding, quite frankly, that you can never, ever eliminate the questions of what is safe for the public without having public views of safety at least be part of the conversation.
Now, Karima, we've only got about 10 seconds. Do you have a response to that?
I mean, I think that part of the reason we see an overrepresentation of certain demographics is because of over-policing in those communities, and they're under more scrutiny. So I think that can become a vicious cycle.
Well, I want to thank you both so much for joining me today. It's been a really important conversation about a big change to the law that's going to have a big impact on the justice system. So thank you both for your time today and for your contribution.
Thank you.
Thank you.
We've heard today about how mandatory minimum sentences can play a role in the justice system, but that role must be limited to only specific offenses. It would be unjust to punish a non-violent person suffering with a drug addiction with a mandatory jail sentence. In prison, their addiction could worsen, their opportunities shrink, and they'd be exposed to hardened criminals. But the government is also planning on repealing mandatory minimums for offenses that are violent, including gun offenses. Does serving justice require the elimination of mandatory minimums for these violent offenses too? And consider that mandatory minimums remain in place for certain non-violent offenses, like impaired driving. The government must strike the right balance. Mandatory minimum sentences swung the pendulum too far towards incarceration over the last decade, and the pendulum is now swinging back. How far should it go? You be the judge. I'm Christine Van Gyn, and remember, a freer Canada starts with you.